Hi, everyone. I know we're still waiting for a few more people to trickle in, but I wanted to welcome you all to our career development series of the month, which is to know your employee rights, job exits, leaves of absence, and toxic work environments. We're really fortunate to have with us an amazing attorney who comes highly recommended by her clients as well as her peers in the industry. She basically represents individual plaintiffs in labor and employment cases, focusing on harassment, retaliation, and discrimination, as well as wrongful termination cases. Amber represents clients in the state of California, particularly the greater San Francisco Bay Area. And she is also, I believe, you're a rising star, which is a huge honor in the attorney side of things. Is that correct?
Yes. Yeah.
Yeah. And Amber has worked in the area of institutionalized harassment and discrimination in the last decade, both in advocacy and research roles. And her ethos is to support those when it matters most and make their voices heard. And she's got a lot of great industry leading organizations that she's a part of or even leads. And so, we're really excited to have Amber here, especially as we have heard from many of you that especially over the last year and plus over the pandemic, that there's been lots of things that have been going on. Of course, this year, many in our community and around the world have faced various layoffs and so on. And so I think a really important thing that we don't typically talk about is actually knowing your employee rights. I feel like so many of the time we focus more on just job search and where your career will go. But I think this is really truly an area that is important to know about. So I'm really excited to have Amber join us today and share her thoughts and what she's seeing and answer your questions. And again, if there are questions that are sensitive, that are anonymous, please feel free to chat them directly to me so I can ask that anonymously. This session, the main part of the session is recorded and we'll take a vote. We'll pause to take a vote to see if we want the Q&A session to be recorded just for to protect privacy. So without further ado, Amber, I will turn the floor over to you.
Thank you, Wendy. It is a great pleasure to be here. I'm so excited to talk to all of you. One of the aspects that I love about my job is just how varied everyone's experiences are and the kinds of questions that they bring to the table. So I'm hoping that this can be pretty interactive and adaptable to what you all are looking for information on. So I'm going to do a little bit of a presentation to try to hit some of the bigger topics that Wendy and I previously discussed. And of course, if there are questions that you have along the way, please pop them in the chat and I'm happy to answer them in real time, or we can save those toward the end of the session. We're focusing on three broader categories today, which would include dealing with separations from employment, whether that's resignation, layoffs, or termination, and how to balance your interests there. We'll also discuss leaves of absence, since a lot of individuals have to take a leave for a medical reason, pregnancy, disability, et cetera. And so understanding your rights there. And we'll also tackle the concept of a toxic work environment and how to cope with harassment and also how to deal with burnout from the legal side of things. So hopefully that was some relevant information for all of you. And you're, of course, welcome to reach out to me at the end of the session via my email, set up a call, whatever you'd like to do in terms of learning more. I really enjoy the advocacy part of my job, and I like making myself available to people when they need it. So with that, I'm going to start the presentation. Also, I've had a lot of caffeine today. I don't know if you can tell, but I'm chatty Cathy. So let me go ahead and share my screen here. 1 second. Let me see. The awkward transition phase. Okay, and can everyone see that? Yeah, nods.
Yes.
That's perfect.
Great.
So my contact information is here, and I'll repeat it at the end just in case anybody wants to reach out. It's pretty simple, amber@amberleelaw.com, and then my website is amberleelaw.com. To start off, I want to preface this by saying this is for general knowledge purposes. For specific advice, you do want to reach out to an attorney barred in your state. I am barred in California. Every person who comes to me has a unique case based on their circumstances, location, industry, whether you work for a startup or a well-established company, if you're a sole proprietor, different demographics. So I want to give you as much general information as I can today, but I want to emphasize that attorneys are not scary and they are a resource to you. So if you have specific questions related to your personal situation, then you do want to have a one-on-one discussion with an attorney. The first topic that I'd like to address are job exits. I think that this is an issue that's obviously hit the tech industry pretty strongly within the last few months. And I field a lot of calls on a daily basis from individuals who are grappling with impending layoffs, performance improvement plans. They're seeing that their company isn't doing well. They're looking for potential exit. So I wanted to cover some basic concepts here so that you can keep that in mind if you are looking to separate from your employer. So the first thing is performance improvement plans. I get a lot of calls about this, and they go by different names. For instance, career coaching, career planning, performance improvement. And essentially it's when your employer comes to you and lets you know that there are some deficits in the performance and they're giving you time to cure those deficits. One thing to note are that despite what the company policy may say about performance improvement plans or disciplinary or progressive discipline action, there's no legal guidelines for this. They are not required for employers to offer to employees in the state of California. California is an at-will employment state, so your employer can choose to separate from you with no notice of your alleged performance deficiencies, and they do not need to provide you time to cure those deficiencies, and they don't actually generally have to give you notice of an impending separation. So the performance improvement plans usually last like 30 to 90 days. And they are generally made up of some sort of written plan as well as intermittent coaching. And then depending on how you perform in the performance improvement plan, your employer may suggest, propose, offer a separation package. Your employer is not required to allow you to finish the entire plan. So sometime in the middle, they can let you know, hey, it's not working out. In terms of performance improvement plans, there are the regular ones, and then we see ones that often come on the heels of a disability leave or some other, some complaint from the employee about harassment or discrimination. Very often, employees who potentially raise some of these issues may face a performance improvement plan. And so if you have a situation like that, you alert your employer that you're pregnant and then suddenly you're placed on a PIP, then you definitely want to contact an attorney about that type of situation. I broadly want to discuss layoffs as well, since we're seeing a lot of those. In the state of California, severance payments are not a legal obligation on the side of the employer. And based on who your employer is, they may have different structures for issuing severance payments. So, with the bigger companies we've seen like Google, Meta, et cetera, they have a baseline severance package that they offer to employees. And it usually includes COBRA coverage as well. The one thing to note about severance payments is they tend to be negotiable, and people do not know this. They think that they get the severance package and that's the end of the story and they have to sign it. That is not the case. When you receive a severance package, you are within your right, and you're actually urged to do so generally in the fine print of your severance package to consult with an attorney to make sure that you understand what you're signing and potentially negotiate the severance package. It's generally a starting point. Now, some employers will stick very hard line to the severance packages that they offer because they want it to be uniform across the board. And some are much more open to negotiation, but you don't know if you don't try. The thing to note about severance packages is I have not seen an employer revoke a severance package when an employee has asked for a negotiation on the monetary amount. So the risk is very low to you in terms of asking an employer, hey, is this amount open to discussion? Can I increase my COBRA coverage? Do you offer outplacement services? Severance packages are generally offered as a starting point. That isn't a guarantee that your employer is going to increase it if you ask, but it's worth an ask. The other thing to note is when you're subject to a layoff, you are eligible for unemployment benefits. I urge you to apply for unemployment benefits as soon as your last day hits, because EDD is very impacted. I have a lot of people say, well, maybe unemployment isn't that much money and I'd rather not bother with it. Totally up to you, but it is money that you have contributed to your own fund over the course of your employment. So you do want to take advantage of it, even if it's not a massive amount of money for you personally. It's worth it to take advantage of the money you've saved for that purpose. The thing that we've been seeing a lot this year is the WARN Act. The WARN Act is a requirement that employers who are laying off more than 50 employees provide employees a 2-month notice period of full pay and benefits. It is an inactive transition period, so you're not expected to work during that period, and you receive your regular paycheck, regular benefits. So if you know that your layoff is pretty big, then you should be eligible for the WARN Act notice period. It's helpful because during that time you can job search and there isn't a gap on your resume. And of course, there's no interruption in your healthcare plan. So the WARN Act definitely protects employees who are working for those bigger companies and are subject to these larger layoffs. Let me just check it. Sorry, let's see here. Oh, whoops, I went back. Okay, well, I just don't know how to go back now because I'm inept at technology.
Can you try just try the back button?
Let's see, I did that. No, we'll just we'll ad lib. But going back to resignations really quickly before hopping into separation agreements, individuals will approach me and ask, especially upper level executives and managers, they reach a point in their career with a company where they're looking to separate and they're not sure how to initiate that conversation with their employer. It is very difficult to negotiate a severance package if you are resigning. So my suggestion is to reach out to an attorney before you provide notice to your employer or even suggest a potential separation to understand how to best approach the negotiation process. Often when I speak to high-level executives and again, managers, the reason that they're thinking of resigning is due to a change in the company's practices or goals. And when that happens and their jobs are materially changed, there is an option to resign with a severance package if you play your cards right. So again, that isn't, there are no guarantees necessarily, but it's an option to explore if you are thinking of leaving your company. And then of course there's terminations for cause when there is a suggestion or allegation that your performance isn't up to snuff or some issue with potential misconduct. In those cases, again, if you have questions, you should certainly reach out to an attorney to ensure that your professional reputation remains intact. And even in those cases, often severance is something that can be negotiated. So moving on to navigating separation agreements. Again, I can't emphasize this enough. Lawyers are not terrible people. We're not all out to get you. And I highly recommend that if you are signing an employment offer letter or in a separation agreement, that you do reach out to an attorney. And a lot of attorneys, including myself, offer contract reviews, which is an hour where you get to sit down with an attorney and go through the contract and make sure all of your questions are answered. In the state of California, we have a lot of protections for employees, including limited non-compete clauses, non-solicitation clauses. We don't allow no rehire clauses, which means that you're agreeing never to work for this company or any of its partners or affiliates in the future. And so there is particular language you want to look at when you have a separation agreement to ensure that your professional autonomy is intact, and to also understand the company's obligations to you and your obligations to the company. And again, an hour of your time and speaking to an attorney can really alleviate some anxiety that you may have and ensure that your rights are being met during this process. There are two areas within the last few months where the government has sided with employees and provided some restrictions to employers in terms of language they can integrate into separation agreements. And that includes non-disparagement clauses and confidentiality provisions. And the National Labor Relations Board essentially said that employers cannot put blanket gag orders on employees upon their separation. They cannot prevent them from speaking to local, state, or federal compliance agencies like OSHA or the EEOC or the IRS about their employment with the company. They also say that if you had a negative experience in the company and someone contacts you and says, "How is it to work there?" and you say, you know, the bagels they brought on Friday were stale and my manager was kind of a jerk, that is now legal. Like, you are now legally allowed to retain the right to say those things. Whereas in the past, in the Harvey Weinstein era, employers could mandate that you wouldn't even be able to confirm you worked at the company. So as you can see, it's been a huge change within the last few years of what employees are allowed to discuss outside of their legal counsel or their financial advisors. So I'm sure there might be a couple of questions about that we can potentially answer at the end of the presentation. With standard severance agreements, the rule of thumb is 1 week to 1 month of severance per year worked. So if you work at a company for 5 years, you can expect anywhere from 5 weeks to 5 months of severance. COBRA changed that a little bit, where a lot of companies are using a baseline model of 1 month to 4 months of severance and then additional weeks for every year worked. You do want to, if you're presented with a severance package, check in with HR or whomever you're negotiating with about what their process is for allocating a severance payment. And of course,
Amber, just a quick question. So we got a question from David regarding, are there any changes in gag orders on independent contractors?
So independent contractors are a totally different kettle of fish in terms of what their rights are and how they're controlled by confidentiality provisions. However, as an independent contractor, an employer cannot limit your right to consult with an attorney or to contact any local, state, or federal compliance agency about questions you may have about your relationship with the employer. So if you're subject to harassment, discrimination, or retaliation, or wage and hour issues, then you are totally within your right to consult with, again, a compliance agency or an attorney who can then, if there's, you want to publish a book about how you're an independent contractor with Microsoft and what happened there, they would be able to better advise you as to what you can say and what you shouldn't say. I think the primary confidentiality provisions that I'm seeing are really related to the settlement and separation agreements I'm reviewing as to the amount. Employers hate when people know how much other people were paid, and they're very much sticklers on money. Other than that, if you are dealing with a hostile work environment and you're seeking counsel or talking to friends, they are less likely to pursue claims against you for that. It's a little bit different if you decide to do a TED talk and you name everyone within your department and, air the dirty laundry kind of thing. So I would tread carefully with that. If you do intend on making any public statements about an entity that you've worked with as a partner or as an independent contractor, I do suggest contacting an attorney to make sure that what you're saying does not open you up to unnecessary legal liability. It's a long-winded answer, which is check with an attorney before you say anything, especially as an independent contractor. Oh, there we go. Okay. So in terms of negotiating greater severance packages, again, severance packages are generally a starting point. There is an opportunity to negotiate based on contributions, tenure, if you've recently taken a leave, if there's been a reorganization, if you've recently gotten a promotion, lots of different opportunities and leverage to increase a severance package. And you can also, when you're negotiating, look at non-monetary benefits, for instance, COBRA coverage for an extended period of time for you and your dependents. Equity, you can ask for accelerated vesting so that it won't make you whole, but you can capture another quarter of vesting. You can also
actually on that note, there's a question regarding employee stock grants. If there's no quote unquote acceleration clause in the original contract and that person is laid off prior to the maturation of stock, is there any recourse? Oh my goodness, I can't speak today. Recourse for stock grants which are canceled?
So that is a really great question. Generally speaking, under California law, unvested equity is considered speculative and thus not legally recoverable. So even if you had a case against your employer for wrongful termination and you won, the jury is not going to award you the unvested equity. So what we see with these types of negotiations is asking for a cash payout of potential unvested equity, or if there is not an accelerated vesting clause, you can still request accelerated vesting or ask that you remain on payroll on an inactive status pending the next vesting date. So you can capture that. So that's an option. There are certainly ways to negotiate retaining some of the benefits of the unvested equity, but there are no guarantees because it is considered a speculative thing that, let's say you have a vesting date in a month. You may have chosen to leave the company before the vesting date. It may have been of your own volition, so you wouldn't have been able to capture it then. The company could be swept up by a tsunami. It could go bankrupt. There are a lot of different things that can happen to unvested equity. And so that's why California law says that it's not recoverable as an award by a jury, but you can certainly use it as leverage in your discussions with your employer when you're presented with a separation agreement. And then a couple of other things that you can potentially negotiate would be retirement contributions, potentially prorated bonuses. So there are options to increase a severance package that may not just be monetary. I did want to touch on COBRA really quickly. This seems to be a area that people aren't necessarily familiar with. COBRA is an extension of your employer health plan. However, you become responsible for COBRA payments following your separation. So to go back a little bit, if you have employer health insurance and you're terminated on July 15th, your health insurance will end at the end of July and COBRA would kick in August 1st. And the COBRA premiums tend to be more expensive than your regular health insurance premiums, but you and your dependents are eligible for health insurance and vision and dental, provided that's what your employer offered you during your employment. For you to get COBRA coverage, you do have to elect COBRA coverage via an election form that is sent to you within 30 days. I believe it's 30 days from your separation date. So if your termination date was July 15th, then a third-party administrator will send you your COBRA election form within a couple of weeks, and you do have to elect COBRA coverage. And then you have quite a few weeks to actually pay the premiums for COBRA. So there's a little bit of a buffer period. COBRA is really important because the health insurance system here is not great. And so to avoid any interruption in your health insurance plan, you may want to elect COBRA coverage. However, if you start a new job and you're offered health insurance through your new employer, it may render you ineligible for COBRA coverage. So you would have to go onto your new employer's health insurance plan. But the whole point is to avoid any gap in your health insurance coverage. When we're talking about negotiating a severance package, many employers are open to negotiating COBRA coverage because it's easier for them to write off. But it's a really great option for employees, especially those with families, to get some greater benefit from a severance package. The last thing I'll touch on is return of company property. I get a lot of questions about this. At the beginning of most of your employment opportunities, you're asked to sign a confidential information and proprietary information agreement. which indicate that any hardware, electronic files, or software that's provided to you by the company remains the company's property. And you do have to return that at the end of your employment. I have a lot of people who first, they want to hold on to their laptops or ergonomic keyboards. You do have to explicitly ask your employer if that's okay. More likely than not, they'll ask for you to send it back, and you can ask them to provide you a courier service or a mailing label or whatever it is to get the property back to them. And this is where the snafu happens, is a lot of employees will either wipe their entire hard drives or they will copy their entire hard drives. And both of those things can cause major issues upon separation and can raise some major red flags. So unless you're asked specifically to wipe the hard drive, you should not wipe the hard drive. You should not copy the hard drive at all. I understand that you may have personal documents like Amazon receipts or family photos. You can choose to copy those onto a flash drive, but you do not want to, copy every single presentation or document that you've written for the company. That would be in violation of the confidential information agreement that you signed at the beginning of your employment and open you up to pretty serious legal liability. Again, if you have questions about returning company property, then call an attorney, ask the quick question just to make sure that you're not causing problems for yourself in terms of company property. Let's see. Okay. So I want to touch on leaves of absence. This is a right that a lot of individuals have that they don't realize it, and perhaps there's still a stigma related to having a disability or asking for a leave. But many employers are large enough to be covered by the Family Medical Leave Act or the California Family Rights Act, which allow you 12 weeks of protected medical leave in a year, presuming that you worked full-time the prior year. And so this is an advantage or a benefit that a lot of people don't take advantage of, and you really, really should. If you're suffering burnout or you're dealing with mental health issues or you have a severe case of E. coli poisoning, you should ask your employer to take an FMLA protected leave. If you're taking any type of extended leave, if it's over three or 4 days, you should ask your employer about your rights under FMLA or the CFRA, the California Family Rights Act, because you're entitled to protected leave. Meaning you can take time off and your employer cannot terminate you on the basis of it. And if I had a penny for every time someone called me and said they were scared of taking a leave because their employer wouldn't like it, I would already be retired in like Turks and Caicos by now. So you have a right to take a leave, to take care of yourself and to take care of your immediate family. So your spouse, your parents, your children. If this is something that you're interested in doing, your first step is to reach out to HR and ask for the FMLA certification paperwork. And you fill that out, you have your provider fill that out, you send it back to your employer, and they'll let you know whether or not you're approved for a leave. One of the most common times of taking a leave is for disability or pregnancy. Those do require a medical certification that needs to be updated periodically, and it is the employee's responsibility to provide those doctor's notes to the employer. So you can't just go and say, I want to take a leave. You do generally have to have a provider sign off on that for you. I'll skip the pregnancy stuff. If you have pregnancy specific questions, happy to answer those during the Q&A. The other caveat I did want to mention about leaves of absence is there tends to be a conflation between protected leave and paid leave. Protected leave through FMLA or the California Family Rights Act, CFRA, means that you're allowed to take time off and your employer cannot terminate you on the basis of it. You can take all 12 weeks in one go. You can take intermittent leave 2 days a month. You can take 2 weeks off here, 4 weeks off later. But it means that you get time off from work and your job is safe to the extent that your employer is committed to providing you a comparable position when you return to work. That is different from paid leave. So people call me and they're like, well, where's my money if I'm on FMLA? In those cases, when you're on disability, you would receive disability payments through the state or potentially through a short-term disability policy with your employer. So again, if you're taking a leave, you want to immediately check with your HR. Do we have a short-term disability plan? If not, can you provide me information on how to apply for state disability? You could also just Google search that. But when you're taking a leave, you need to consider, okay, let me make sure it's protected and let me make sure I'm paid. Some employers will require that you exhaust your accrued PTO before taking advantage of their short-term disability plan. So there are little caveats like that, or little nuances that you do want to make sure you understand at the time that you take the leave. The other thing with leaves is it could potentially impact your vesting. So this is something that people don't always know, is that sometimes your vesting schedule is impacted if you're taking a leave. And so you skip a quarter and then it makes it up the next quarter. But you want to check in on those benefits. The same thing with health insurance plans. Some employers, it's rare, will have you pay your own premiums for health insurance while you're on FMLA. So again, this is something you want to keep in mind, so you're not blindsided during your leave about health insurance coverage. The other question I get a lot is when and how to disclose disability and or pregnancy. Never do that before your employment. It is not necessary. It is not required. And you really don't need to do that. I have several failure to hire cases based on pregnancy, where my pregnant employees disclosed pregnancy upon receipt of an offer letter and the offer was rescinded. And I know that there is a desire to be transparent and authentic during the interview process. I totally understand that. But being pregnant or having a disability is private medical information, and you are under no obligation to disclose that. During your employment, a lot of people will call me and ask, when is it appropriate to disclose that I need to take a leave? If you're pregnant, generally giving your employer a month or so of notice is enough. You do not have to let them know, exactly at the 3-week mark or shortly thereafter, or the day after you got a positive pregnancy test. You can wait until you're further along in your pregnancy. And once you do that, they do have a duty to provide you with relevant information about your eligibility for leave and pay and all of that. So again, if you have any questions, then talk to an attorney, and you can do that before announcing your pregnancy, just to understand what rights you have and what to expect during that process. Same thing with a disability. You don't have to disclose it at the time of your interview or the offer letter. You can disclose it once you start. I think the major thing I'd like to flag about disability is very often individuals with disabilities need accommodations, and they sometimes wait too long to request those accommodations. Meaning, let's say you have an audio visual processing disorder that sometimes flares up or is intermittent, and you receive feedback from your employer that you don't seem on the ball for whatever reason. That's when a lot of employees will then submit a request for accommodations, but it looks too reactive, or it looks like the employee is trying to obscure some performance deficiency. So it's much better to disclose the need for potential accommodation before the issue actually arises. So that is a very poor way of saying, or very sort of roundabout way of saying that if you know that you need an accommodation of some sort, whether that's an ergonomic chair or more time to process written documents or to get instructions from your boss in writing, things like that, it's better to alert your manager of that early on versus waiting for there to be an observation of a potential performance deficiency and then having to clear that up.
And Amber, just on that note, in terms of disability, what are some examples of non-obvious disabilities? Like, for instance, is someone who is on the spectrum of the autism spectrum, is that something that would be considered something that can be fileable and so on?
Yes. So disabilities can include physical and mental conditions that essentially impact your ability to do your job. So again, these can be anything from autism. So very often my autistic clients need additional time to process information from their supervisors, or they need instructions in writing, or they're sensitive to particular light or sounds. And those are accommodations that you can request. If you realize that your performance is being impacted by these environmental aspects, you can alert your employer of that, and they have a duty to make reasonable accommodations. So I've seen accommodations ranging from, an ergonomic mouse to allowing an employee to paint their office a different color to ensure that they can work within that space. And it can be for a physical disability, it can be for a mental condition. There's really, the sky is limitless in terms of the types of accommodations you can ask for. The parameters being, however, that the accommodation has to be reasonable. And that is very dependent on the employer. So if you have like a massive company like Google and you're asking for a completely ergonomic work setup installed in your home to allow you to continue doing your job, that's probably much easier for Google to do than a smaller family-owned business who might not have the capacity to do that. So that is one caveat, is the reasonableness of the request. And then the second thing is your employer is required to engage in the interactive process, which means if you let them know, hey, I have difficulty with scents, with fragrances. They may come back to you and say, well, we can't request that everybody use non-scented deodorant, but we will replace the soaps in the bathroom with unscented soaps. We will ensure that our cleaners use unscented deodorizers in your office, that kind of thing. And so they have to come back and kind of work with you on what those accommodations look like. You may not get everything that you ask for, but the employer is required to do their best to make those accommodations a reality. If they cannot make those accommodations, then depending on whether your condition is temporary or permanent, you may be placed on a leave until they can either make those accommodations possible or until your condition lessens to the point you can return to work without the accommodations. Again, if this is an issue that you're facing, I would highly suggest speaking to an attorney to make sure you've covered all of your bases and that your employer is covering theirs. So as you can see, accommodations can be in the form of a leave. Again, that would potentially be protected by FMLA or CIFRA, could be paid or unpaid. It can also be work environment changes, ergonomics, asking for communications. There's a lot in how to ask for accommodations, and usually it is very simple. You can just write to your manager and CCHR and state, I realize that I need these accommodations. I can provide medical certification. Let me know the process. You do not have to disclose your diagnosis or your treatment plan. You just have to let them know what your accommodations are and assure them that you can get medical certification for those accommodations. You should.
And on that note, someone mentioned that their boss gave them grief and was very gruntled that they did not give all the details about their FMLA. So how much do they need to tell their manager versus HR?
That is a great question. You do not need to tell your manager anything past when you are anticipated to return to work and what kind of accommodations you need. You do not need to disclose why you're taking FMLA, if you're receiving treatment, if the FMLA is because you're taking care of a relative. His poor attitude is personal. It's not legally based. And so you can protect that private information and only disclose with what you're comfortable with. In terms of what you disclose to HR, you can let them know that your doctor has recommended a leave. If that's the case, they will provide you certification paperwork and your medical provider fills it out. I have seen so many doctor's notes that disclose an unnecessary amount of information about my client's medical status, and that is unnecessary. All it has to say is that Joe is under my care, he requires a leave, or he requires XYZ accommodations. That's it. It does not need to be a manifesto of every condition or thing that you're being treated for. So I totally understand when the frustration of your manager pushing for further information from you, but know that you do not have to disclose anything past your time frame and if you need accommodations. Okay. One of the most common questions I get now in the post-COVID world is working from home and whether you can ask your employer to provide that accommodation to you. So even with COVID and everyone working from home pretty successfully for the last few years, working from home is not considered a reasonable accommodation, meaning that an employer is not required to allow you to work from home, even if your doctor recommends it. And even if your job could be performed remotely and has been performed remotely this entire time. So, employers have the discretion to require employees to return on site. And I've seen like really strange cases. For instance, like I have an employee who's perfectly able to do her job at home, a non-employee client who can do her job from home, but they've asked her to come back to work. And she's immunocompromised. So it's better for her not to be around people. And they said, that's fine. We'll just put you in a private office where you don't have to see or talk to anybody else throughout the day, but we want you to work on site. And so it's kind of strange because it's potentially costing the employer more money and making things a little bit harder for them. But they have the discretion to require an employee to work on site. They do not have to accept a doctor's recommendation that you work from home. I understand that's frustrating for a lot of people, but so far the law has really been stuck on the point that employers have discretion to have you work on site versus working from home. So the last sort of broader category I will chat about, because I know that we want to leave room for questions, is navigating a toxic work environment. So first, I want to draw a distinction between a toxic work environment and a hostile work environment. A toxic work environment we've all had. It's the unprofessional manager or the disgruntled coworker. It's the lots of yelling, throwing things, unreasonable deadlines. That's toxic. And unfortunately, that is legal. A hostile work environment is one where you're being particularly targeted based on your membership in a protected class, meaning your age, race, disability, gender, sexual orientation, national origin, gender identity, etc. So when people call me and they say, I have a toxic work environment issue, we have to differentiate what is toxic, meaning you have a work environment that is undesirable versus a hostile work environment where there is illegal activity happening, specifically harassment, discrimination, or retaliation based on your membership in a protected class. I have a lot of people call me who say, I was just terminated and I'm pregnant. Isn't that illegal? No, you have to show that the adverse employment action, termination in this case, happened because you were pregnant, not that just you happened to be pregnant at the time that the termination occurred. So again, if you're faced with a situation, I highly recommend you talk to an attorney to understand what kind of legal exposure the employer is facing and what kind of rights you have in that situation. Piggybacking off of that, there is a difference between bullying and harassment. Harassment is a legal word of art. And that means, again, that you're being targeted based on your membership in a protected class. Whereas a lot of us have had supervisors who are bullies, who are rude, unprofessional, immature, who use aggression as a leadership tactic. And unfortunately, those types of behaviors are not legally actionable. They may be in violation of company policy, which is another question, but they're not legally actionable. In cases of a toxic or hostile work environment, I highly recommend documenting these issues that you're facing. You can keep your own private log, of your interactions with a manager or a coworker that you feel are problematic, and you do want to keep that in real time. If it is a situation that is escalating and you feel unsafe in the work environment, or there are behaviors or comments that are inappropriate related to membership in a protected class, then you should reach out to HR. And it can be a very quick note. It doesn't have to be caustic or a formal complaint. It can just be a quick email to HR. Again, like, hi, Joe Schmo, I work in this department. I have noticed some communication issues with my manager based on XYZ. Do you mind if we schedule a chat to discuss options moving forward? And so it doesn't need to be something like, dear HR manager, I am so angry and hurt and want to bring a lawsuit, and this needs to be fixed and you need to fire this person, everybody needs to go through training, you're coming in hot in that case. What you want to do with documentation is keep HR apprised of these communication issues and provide the employer an opportunity to respond. They don't always respond. They don't always respond well, but it's much stronger for you in terms of leverage and maintaining a copacetic work environment to document those concerns concisely and promptly. And again, if you're faced with an issue like this, I certainly urge you to contact an attorney to ask how to best verbalize that to ensure that you're using language that protects you moving forward. Concerns regarding proprietary information and company property. I've had this come up in a few different ways. One, people moonlighting. Very often in your employment offer letters, there are provisions against moonlighting or working for competitors while employed by your employer. Within the tech industry, we often see people taking multiple jobs within the same industry at the same time. That can cause some problems for you. The other thing is if you're moving from job to job and you're adapting templates that you've used at prior employers at a new employer, that can also be problematic in terms of moving institutional knowledge from one entity to another. So this is an issue that often comes up within the tech industry in IP. So again, tread carefully and talk to an attorney if you have questions about that. One note is that when individuals have been subject to harassment, discrimination, or retaliation, their first line of defense is to file with the EEOC, or at least they think it is. The EEOC is the Equal Employment Opportunity Commission, and that is the federal entity that handles harassment, discrimination, retaliation claims. California has its own, which is called the Department of Fair Employment and Housing, the DFEH. If you file with one in California, it will counterfile with the other entity, so you don't have to do two, it's just one. I highly recommend contacting an attorney before you file any charge with the EEOC or the DFEH to ensure that it's drafted correctly and to make sure you understand the timeline. With the EEOC, your timeline can be as short as 45 days between filing the complaint with the EEOC and having to file a lawsuit. So if you don't have an attorney and you're not prepared to do that, you may lose your chance and lose your legal claims if you're not fully prepared before filing with the EEOC. So I just really want to warn people. I get a lot of calls where individuals say, I have to file a lawsuit tomorrow and I didn't know that. Like, what do I do now? It's very hard for an attorney to be able to file a lawsuit for you in that short of a time period. It usually takes at least 2 to 3 months to get caught up and file something like that. So you don't want to shoot yourself in the foot by filing with the EEOC or the DFEH too quickly. There's some statute questions or statutes and other complications there, but we'll move through that unless there's specific questions I can answer during the Q&A. Again, you're always welcome to reach out to me or any attorney for guidance on that. The last thing that I wanted to touch on is coping with burnout. We had a question that was submitted prior to today regarding dealing with burnout with employees and what an employer and employee's responsibility is in coping with that. We see a lot of burnout, which is essentially people being overworked and undervalued. And it just leads to a point where an employee is unable to move forward with their job, or they're at the brink where they just want to quit because it's just too exhausting, or their work performance is suffering because they don't have the energy to move forward. If you're faced with a situation like that, you should most certainly consider a medical leave. And generally your primary doctor will approve that for up to 12 weeks. And that's something that you should take advantage of. If you are an employer and you're thinking about, or you're thinking about starting your own business, I would suggest being very deliberate about how and when you scale your company. The biggest issue I see with startups are that employers are not fully apprised of what it takes to keep employees happy and productive. And there's a couple of things that happen. One is that usually an HR team is not fully built out at the time that the company expands. So you have 1,000 employees and you have like a half an HR person, or you have someone who's substituting in as an HR person, but they aren't a trained HR individual. They don't understand the legal rights and benefits that the employees are accorded. There's been no meeting of the minds in terms of what those benefits look like and how the company is going to handle these issues as they come up. So that's one thing, is having an inadequate HR system. If you are starting a business, you do want to make sure you have an employee handbook, you have policies related to disability, maternity leave, health insurance, and make sure that you know how to fully communicate that to your employees. And the other thing is ensuring that you have a very strong infrastructure. So one thing that we see often is the flattening of the hierarchy within work environments, where it's like the CEO has an open door policy. So anyone can go up to the CEO and say, hey, I've had this issue. I want to talk to you about it. In theory, that is a great idea. We love an open door policy until you have to complain about the CEO. Who do you go to? How do you protect yourself? And that's where having an HR or a chief people officer is incredibly important. And that isn't something that you want to wait to address when the company is already too big and these problems are already occurring. And so my suggestion for individuals who are hiring is to ensure that you have a very clear plan in terms of handling conflict within the company, benefits within the company, medical leaves or disability leaves within the company. Make sure you have all of that figured out before you bring on a ton of employees and you're in over your head. So that is those are sort of the highlights of some of the issues that I've been seeing more regularly. I know that is a ton of information and I talked really fast. Some of it was probably more relevant and other parts not so much. But hopefully it gives you some ideas to think about in terms of your own personal situation. And at this point, we can go ahead and take some questions.
Yes, so maybe I'll start with thank you so much for that wealth of knowledge, Amber. And maybe I'll start with two of the questions that were asked. One is, how much does it cost to consult with an employment lawyer?
Yes. So to consult with an employment lawyer, it can vary. And some attorneys work on an hourly basis, and that can range from $250 to $500 an hour if you need a full hour of advice. With my job, I try to offer 15-minute consultations with potential clients just to ensure that people understand what their rights are. And a lot of attorneys do offer this. So you can call an office and say, I just have a couple of questions. Like, do you have availability? And a lot of attorneys will offer their time for 10 or 15 minutes. Some firms, however, will screen you out and a paralegal will say, well, if you don't have a clear harassment case, the attorney isn't going to spend time with you, which I think is unfortunate, but just check around and see if you can get an attorney on the phone. The other option is there is an organization called Legal Aid at Work. It is a nonprofit based in San Francisco, and their website is great, and they do have a hotline. So you can always check with them and see if you can get your question answered. If it's very sophisticated or high level, you may have to retain an attorney for hourly advice at their hourly rate. I do want to flag that there was a question about HR being there to protect the company. And your doctor being trained in accommodations and what's reasonable and what's not. That is a very salient or insightful comment. HR is there to protect the company, but unfortunately you have to utilize HR to the extent of protecting yourself if there is a risk of harassment, retaliation, or discrimination, which is why sometimes reaching out to HR is really just for the purpose of creating a paper trail and demonstrating that you've done your part, which is communicating your need for accommodation, putting the employer on notice that you have a disability or a need, and affording them the opportunity to address that need. I will agree with Peter that a lot of doctors are not trained in communicating with employers, either related to medical information and or accommodations. And that's when having an attorney is really helpful, because they can tell you, your doctor does not need to include information about your cancer diagnosis and chemo. They just have to say that you're under their care and you can't work for 6 weeks. And And they can also let you know what's considered reasonable and unreasonable in terms of having your doctor issue that note to the employer. Some doctors will write accommodations like, you know, my client needs to take a 5-minute break every 15 minutes. Sometimes that's not feasible in light of meetings or your job and responsibilities. And so working with an attorney and working with your doctor simultaneously can be very helpful.
Yeah, there's oh, sorry, go ahead. Were you finishing that question?
Yeah, so I think just skipping to the next one, I think what's community burnout? And less community burnout, but more of the idea of building community within your company and creating and this can come from the employee or the employer side, is creating an environment where individuals and groups feel respected and feel heard. And there's a multitude of ways of doing that. I have seen many companies hire community specialists or community builders who come in and create affinity groups or create programming or professional development units or curriculum for employees that help them feel more supported, especially when it comes to things like burnout or diversity and inclusion or upward mobility. So if you are starting a company or you want to provide guidance to your employer about how they can improve the work environment, one of the big things we see is community building, and that's been helpful in a lot of companies that I've worked with and or sued.
Yeah, so we have 2 anonymous questions. Someone was laid off from work and was not paid their final paycheck on the last day. They were finally paid 26 days late after emailing several times. This person's asking, there seems to be penalties for this in California. What is the best way to go about getting these California waiting time penalties from the employer?
That is a great question. So just for general knowledge, your employer is required, if they are laying you off or terminating you, they are required to provide your final paycheck within, or they have to issue your final paycheck within 24 hours of your last day. And that includes your PTO. Your employer cannot condition your final paycheck and or accrued PTO on you signing a severance agreement. A severance agreement is for something extra. You always get your final paycheck and your accrued PTO. They have to issue it within 24 hours of your last day if you're being terminated or laid off. If you are resigning, then they have 72 hours to do that. If they fail to issue your paycheck and accrued PTO within that time frame, then you would file with the Department of Labor for waiting time penalties. And it can actually add up rather quickly. So it is worth it to file with the Department of Labor. I will note that the Department of Labor is a bit impacted and a bit slow. So you do have to be patient, but they will get to your case. Alternatively, you can retain counsel depending on what the waiting time penalties are. If it's a few $1,000s, you may want to consult with counsel to write a demand letter for you to recoup that those waiting time penalties and interest. But it really just depends on how much is at stake and whether it's worth it to hire an attorney for that. If your waiting time penalties are $500, you would just want to file with the Department of Labor.
Yeah, there's also a question on moonlighting. So someone read on the Blind app forums that their employer allows moonlighting as long as they're not working at a competitor company. So do you have guidance such as 1, areas of my employment contract that I should check, and 2, whether I need to notify my manager, and 3, anything else?
Right. No, that's a great question. So a few guidelines. 1 is that within your employment offer letter or employment contract, it will have a moonlighting provision. Sometimes it's called concurrent employment or a non-compete clause. So those are a couple of ways that it can be phrased in your employment agreement. If there is no such provision, then you would want to check your employee handbook, and it may be covered there. If the guideline for moonlighting or having a side hustle is that if you're being hired to do a full-time job, then you need to be available full-time to your employer. If their hours are Monday through Friday, 9 to 5, then you're expected to be available 9 to 5, Monday through Friday. If you are working concurrent employment and your concurrent employment or side hustle requires that you be available during those business hours, and you are not available during those full-time business hours for your primary employer, then that's the time where you may have to disclose that you have another position. But before doing that, again, I would consult with an attorney to ensure, one, that you aren't in clear violation of your employment offer letter or employee handbook, and you're not opening yourself up to an imminent termination. But also to present ask the employer to allow you to keep both positions. There is a nuanced way to do that that could net more positive results than you just emailing your manager and saying, hey, I know I'm supposed to be here, Tuesday and Thursday, but actually I've decided to take a job as a Disneyland ride operator on those days, so I'm just not going to be here. That would not go over well. One of the things that I see with a lot of employees is a sense of reactivity. So you hear something from your manager about a performance improvement plan, or you find out you're pregnant and you want to tell everyone. There's like, for some reason, a lot of people want to act immediately. And when they do that, they can actually reduce their leverage or undermine their own rights. And so before jumping into those conversations, do your research, check with an attorney, and make sure you have a game plan moving forward. So that's my biggest piece of advice, is avoid the reactive positioning, take a deep breath, check, get some coaching, get some advice, and then move forward.
And I do recognize that it is over 5 p.m. So I'm also cognizant, Amber, you may have other things, but if you're willing to stay a few more minutes, looks like there might be a few more questions, but totally okay, because I know we have you booked for 4 to 5. So understand you have your clients to get to as well.
No, I'm open for another 15 or 20 minutes. So happy to answer additional questions.
Perfect. There is one more question regarding the earlier question on penalties. I'm guessing on delay of payment. Then can you file a claim with the Department of Labor even if you sign a severance agreement / general waiver, or could someone just ask their employer directly for the penalties?
So that is a great question. When you sign a severance agreement on the date of your termination, let's say, you are certifying that you've been paid all bonuses, commissions, your accrued PTO, that sort of thing. But you're only releasing claims up through the date that you signed the agreement. So if they fail to pay you afterwards, your final paycheck, or they fail to pay your accrued PTO, those claims arise after you've signed the agreement. So you still could potentially file a claim with the Department of Labor. Even if you've certified in the severance, the general release, that you've been paid that amount. I would suggest filing with the Department of Labor, even if you have filed, even if you've signed a severance agreement, because of that provision that when you sign a general release or a severance agreement, you're only waiving claims up to the date you sign it. So it's not covering anything that would be owed to you after that time. And also because accrued PTO and your final paycheck, those are yours. You have worked those hours, and thus you are due that amount, regardless if you've signed a severance agreement.
Oh, there's another anonymous question. Can you speak to what constitutes as age discrimination as it relates to layoffs, please?
Yes, that is a great question. So the age discrimination is primarily laid out in the Age Discrimination and Employment Act and the additional case law, and it protects employees over the age of 40. So if you're over the age of 40, then you are protected by the Age Discrimination and Employment Act. I have a lot of people calling me who are like 21, 22, 24, whatever. And they're like, I feel like I'm being discriminated against because I'm younger. Unfortunately, that isn't a protected class. It's for individuals over the age of 40. The ADEA, Age Discrimination and Employment Act, provides additional protections to employees over the age of 40 at the time of separation. That includes 21 days to review a separation agreement. If you're under the age of 40, your employer can give you 2 hours to review a separation agreement or severance agreement and sign. If you're over the age of 40, you always get a minimum of 21 days. You're also urged to contact an attorney and have them review the contract with you. And additionally, for people over the age of 40, you get a 7-day revocation period. So if you sign the agreement, it does not become effective for 7 days, and you have the opportunity to revoke your signature, buyer's remorse. Generally speaking, if you're under the age of 40 and you sign an employment agreement and your employer signs it, it is a binding contract and you can't get out of it. You've bound yourself to it by signing it. If you're over the age of 40, you get those extra 7 days. The other benefit accorded under the Act is at the time of being separated, and if it's part of a layoff, you receive an addendum to your separation package that lists everyone who was laid off and their ages. And this is to track whether a particular demographic is being targeted based on their age. Now, I wish employers did this for everything: race, pregnancy status, disability status. It would make my job way easier. But right now, it's just for individuals over the age of 40. I would say that the 40 benchmark is becoming sort of less important as time goes on, because so many people are working into their 70s or so. I would say that if you're over the age of 50 or 55 and you feel that there's age discrimination going on, certainly consult with an attorney. If you feel like you're not being given enough employment benefits or opportunities, if there are comments made related to retirement, or don't you want to spend more time with your grandkids, or, you know, hey, grandpa, or something like that, definitely talk to an attorney about potential age discrimination. But it is very common within the tech industry, I would say. So it's certainly something to keep an eye out for. Oh, the other thing I wanted to add about severance agreements is, employers will often say, you have 5 days to sign the agreement, or 2 weeks. You can let an employer know if you need additional time. And I would say that they very often will provide you more time to consult with an attorney and to sign any separation agreement. They don't always do that. It's no guarantee, but it's worth an ask.
All right. Any other questions? Feel free to type them in anonymously. I just want to echo Amber. There's been tons of comments to me anonymously and also in the general forum to say that this has been an incredibly useful session, or rather enormously is a word. And so thank you so much for doing this. There seems like lots of head nods and likes for that. So just want to say this is gold, and we don't typically talk about these things, but I think this is really important. What are the most common scenarios you're seeing nowadays with valid cases?
Yeah, that is a great question. So wow, it's a big question. I have a variety of cases. I would say one of these emerging issues I'm seeing are gender identity cases. So I have a couple of transgender clients who certainly needed some advocacy. Within the tech industry, I would say that there's a fair number of gender-based claims or pregnancy-based claims. So that's quite common. And also disability. I think that a lot of employees have difficulty asking for accommodations or verbalizing their needs to the employer. And very often that escalates to a point where the employee is receiving unwarranted performance criticism based on a disability or a leave. And when they come to me, they're in a really tough spot. So I would say that those are 3 of the main things that I work on now. But I do everything. So again, I have race-based cases, disability cases, gender identity, national origin. Unfortunately, these legal issues are still quite prevalent, despite major progress our state and our country has made in the last few years. Also, great question about PIPs. This is a great question. What if you don't agree?
Can you just repeat that for the online audience who will later look at this video?
Yeah, so the question is, what can you do when you don't agree with a PIP or you think it's unfair to receive one? That is a great question. So when you receive a PIP, you may not agree with it. You do have to acknowledge receipt. So if you're presented with it in writing, you would sign I've received this. I do not agree with the contents contained within this agreement or this document. If you are placed on a PIP, you're given an amount of time to remedy the potential deficiencies, and you do have to show up and try, I would say. I have had a fair number of clients who come to me and they've attempted to rebut a PIP. And so they write a manifesto where they go point by point as to why they think their manager is wrong. Generally, that just is not as helpful as you would think. It sometimes appears combative, or it escalates a situation. So before responding to a PIP point by point, I would just say, I don't agree with this PIP, but I'll work with you in terms of whether that's doing weekly check-ins with your manager or working on those deliverables. You do want to note that you believe that the PIP is not an accurate reflection of your performance. If you think it's retaliation, then you should certainly contact an attorney to figure out if there is enough grounds for a potential retaliation case, or figuring out how to navigate that. I often see PIPs assessed when an employee has made a complaint about a manager based on a membership in a protected class, when an employee has returned from a leave or requested a leave or disclosed a disability. If I would say those are actually the times where being placed on a PIP can create legal liability for the employer for a retaliation claim. And so one thing to note is that because California is an at-will employment state, your employer has a great deal of discretion in terms of issuing PIPs and also resorting to termination. And again, they can do that without any notice, but you are also in a position where you do not have to subject yourself to a PIP or a toxic work environment. You can also choose to leave. And if you are considering that after being placed on a PIP, contact an attorney and ask them what the best way to approach your exit would be. Sometimes your manager may say, hey, we're going to place you on the PIP, or you can choose to take the severance package. If you're offered that opportunity, you may want to consider it. And you would want to contact an attorney to figure out how to maximize your severance package. So even if you're faced with a PIP, there are often ways to use that as leverage to negotiate a more amicable exit. The other thing with PIPs is, often these are issued by managers. If you feel that you need a third party there, you can either involve your skip level manager or HR. And again, there's a way to do that that doesn't appear combative and demonstrates a level of cooperation. Even if you don't feel like you want to cooperate or show goodwill, it is really an important step to put yourself in a good leveraging position if you're faced with a separation.
And we had an anonymous question come in as well. What is the statute of limitations for lawsuits related to employment contracts like severance packages?
Okay, so that is great. So there are varying statutes, and it would be hard to go through all of them. I would, generally speaking, if you have harassment, discrimination, or retaliation claims, then you have 3 years in California to file with the Department of Fair Employment and Housing. Under federal law, you have 1 year from the date of harm for harassment, discrimination, and retaliation to file with the EEOC. So it's kind of strange that we have these different deadlines. For wrongful termination, it's I always say 2 years. It can be 3 years, but I would say to tread carefully. 2 years for a wrongful termination claim. There are also different statutes for wage and hour claims. So again, you would contact an attorney to ensure that you have enough time to file on those claims. When you're talking about, with legal claims related to severance packages, that's a different question, because if they don't pay your severance or they don't pay your final paycheck, those are different timeframes that we're talking about. But again, if you're sure that your employer has committed some sort of illegal action, then you would want to contact an attorney to make sure you know what the statute of limitations is for that particular claim. And so David brought up a good question. Why do employers offer severance agreements for letting go of at-will employees? So they have an interest in having you sign a general release, which creates this tabula rasa, a blank slate for them to ensure that they aren't going to be hit with a lawsuit later. It allows them to ensure that an employee has turned back all of their company property, that they're going to adhere to a confidentiality provision. And so the employer has an interest in having employees sign that general release paperwork. And then, of course, with the WARN Act, in larger employers who are laying off 50 or more employees are required to provide that notice period. That's instituted by law. That isn't an option for employers not to adhere to if they do fall under the WARN Act eligibility requirements.
All right. Well, thank you. I'm just going to leave like 30 more seconds to see if any more questions come in. If you do, please either raise your hand or also or ask that anonymously. And Amber, would you mind just putting on your contact information again? Because I know that question was asked earlier. So if anyone do have additional questions, they'd like to reach out to you, it'd be great to just have that information. Perfect. And so that's Amber at Amber Lee Lee law.com, and the website is Amber Lee Lee. So Amber Lee law.com. So thank you so much for this incredibly helpful session, and thank you for going over your time as well. Really appreciate it, and thank you for all the advocacy you do for all the employees out there.
Thank you. It was a pleasure again. And please feel free to reach out if you have any questions. And I hope all of you have a great day. And I just want to let you know that, these really difficult situations can happen at work, but you do have options and you do have support. So, I think that it's just really important to recognize that you have people who can be in your court and can take care of you and provide that advocacy, and you should not feel alone in navigating, whether it's a severance package or an issue with harassment at work. You do have options. So I just want to underline that because I know it could be really scary for a lot of people.
Thank you so much, Amber. All right, thank you everyone. And wow, this is a record. Everyone, more than half the attendees staying on past the hour by 20 minutes. So thank you all for your time and for your attention as well. And until next time.
Bye guys, thank you.